There is a procedural device called the pro forma session. It appears in no law you have ever read, and it has been used without a single interruption since December 19, 2007, to cancel a power the Constitution gives to the President of the United States. Most of these sessions last less than 30 seconds. No debate happens, no vote is taken, and it works every time. Here is what a pro forma session actually is. The Constitution says a president can fill certain vacancies without Senate confirmation, but only if the Senate is in recess. So the Senate simply stopped taking real recesses. Every few days, a single senator, sometimes alone in an otherwise empty chamber, gavels the session open, declares there is no business and gavels it closed. On paper, the Senate never left. In practice, almost nothing happened. That 30-second ritual is enough, legally, to say the body was never gone long enough for the president's power to switch on. This did not come from a bill. It did not come from a floor vote, a committee hearing, or a public hearing of any kind. In December 2007, Senate Majority Leader Harry Reid ordered the chamber to be gavelled in and out every few days specifically to block President Bush from making recess appointments Reid did not want confirmed. Nobody amended the Constitution. Nobody passed a statute defining what a recess is. Reid used a clause most Americans have never heard of, Article 1, Section 5, which says each house sets its own rules for how it conducts business. A scheduling decision made by one man's staff became a permanent constitutional workaround, and once it existed, no future majority leader of either party ever gave it up. Here is the complication. This is not a Democratic tool or a Republican one anymore. It is now standard operating procedure regardless of who runs the Senate. Whoever holds the majority leader's office controls it completely. They decide when the chamber pretends to be in session. They decide which senator gets assigned the 30-second gavel duty, sometimes rotating it like a chore. There is no oversight body reviewing whether the practice is being used fairly, no reporting requirement, no public log explaining why a given week was carved into fake sessions instead of a real recess. It survives purely because both parties have found it useful when they hold power, and inconvenient only when they don't. Now here is where it reaches you directly. This rule decided real cases. When President Obama tried to make recess appointments to the National Labor Relations Board in January 2012, believing the Senate was genuinely on break, those pro forma sessions were the legal basis used to challenge him. The dispute went all the way to the Supreme Court. In 2014, in a case called NLRB versus Noel Canning, the court ruled unanimously, 9-0, that pro forma sessions count as real sessions, as long as the Senate retains the capacity to conduct business if it chose to. Not that it does conduct business, that it could. That single sentence validated the entire workaround. It meant labor board rulings affecting union elections and workplace disputes across the country were thrown into years of legal limbo, because a procedural trick born from a staffing decision in 2007 was now treated as constitutionally sound. Ordinary workers with cases pending before that board had their outcomes shaped not by a law Congress passed, but by whether a senator showed up to bang a gavel for 6 seconds every third day. This cannot be repealed because there is nothing to repeal. It was never legislation. It lives entirely inside the Senate's constitutional authority to govern its own internal proceedings, a power courts have always refused to second-guess. Noel Canning did not just permit the practice, it insulated it by ruling that as long as the Senate says it's in session, the judiciary will not look behind that claim. Reversing it would require a majority leader to voluntarily surrender a tool that costs nothing to keep and protects every future president's appointment fights from their own party. No one with the power to end it has ever had a reason to. What this should tell you is bigger than one gavel. It means an entire branch of government can manufacture a constitutional workaround using nothing but scheduling, and the Supreme Court will bless it as long as the fiction is maintained cleanly enough. If a chamber of Congress can neutralize a presidential power this way, quietly, permanently, with zero public vote, you have to ask what else currently operates on your understanding of the rules. That was never actually written into any rule at all.